without any further ado, can I invite Mr Justice Foxton to come and give the 2025 Birkenhead Lecture?
The Earl of Birkenhead, in whose honour this lecture is named, is still, I think, best known to us as F.E. Smith, or simply F.E. His fame today largely rests upon his reputation as the master of the courtroom bon mot and scourge of a slow-witted and pompous judiciary. But he was also a central figure in the great constitutional drama of his age, one which dominated British and Irish political discourse from at least 1798, and the aftershocks of which still reverberate, happily in much diminished intensity, today. That controversy is the so-called Irish question, the constitutional relationship of the island of Ireland and its parts with its larger neighbour. My subject this evening is the occasions when that controversy made its presence felt in the English courts. Any study of the history of Anglo-Irish relations must always answer the questions when to begin and when to end. Writing in 1966, my one-time supervisor, the late Professor Paul O'Higgins, began an article with the same title as this lecture, with Cook's Case of Proclamations in 1611. You will be pleased to hear I do not plan to go quite so far back, but largely to frame my treatment by reference to F.E.'s own involvement. But we are going to continue beyond the point when F.E.'s engagement with the Irish question ceased, acutely conscious as we do so that the move from the historical to the contemporary leaves less and less of interest for the serving judge to say. Shakespeare, through Jacques, famously told us that we are all players on a stage who in the course of our lives play many parts. That was certainly true of F.E.'s involvement with the Irish question. Not all of those parts were wholly creditable, and we begin with one of the less impressive. By the early 20th century, there was a clear majority of Ireland's 100 MPs in the Westminster Parliament who supported Home Rule for Ireland. And in that endeavour, they had acquired the support of one of the major political parties, the Liberals. Home Rule, at least on an all-Ireland basis, was bitterly opposed by a significant minority of the Irish population of Protestant religion, largely concentrated in the northern counties in Ulster, whose interests are frequently described by reference to that province. They too had their allies in mainstream British politics, in F.E.'s Conservative Party, and with F.E. one of their most fervent supporters. Once it became apparent that a combination of the parliamentary arithmetic and the abolition of the House of Lords veto through the Parliament Acts was likely finally to place a Home Rule measure on the statute book, many of those opposed to its implementation in Ulster formed an armed militia called the Ulster Volunteer Force, or UVF. The Southern Unionist MP and barrister Sir Edward Carson, later himself a law lord, established himself as the Unionist leading spokesman. There were demonstrations of UBF military strength at large gatherings, and Carson spoke with F.E. generally at his side, often in military uniform of indeterminate origin, riding a horse up and down the massed ranks, earning himself in the process the not-so-fond nickname Galloper Smith. He also spoke at anti-Home Rule rallies across the United Kingdom. His rhetorical contributions included proclaiming that there were no lengths, however desperate and unconstitutional, to which Ulster would not be entitled to go in resisting Home Rule, nor any in which he would not support them. He said that if he were an Ulster Protestant, he would rather be ruled from Constantinople by the Sultan of Turkey than by nationalist leaders, and that if the Westminster government sought to implement a Home Rule bill by force, ministers will end up swinging from the lampposts of London. Here, therefore, was an MP, barrister and King's Counsel, a future law officer, Lord Chancellor and Judge, actively fomenting armed rebellion for the purpose of resisting the legislation of a democratically elected parliament. Now, the United Kingdom avoided the civil war which the Home Rule Act 1914 might otherwise have precipitated, only by the happening of an even greater cataclysm. The outbreak of the Great War led to a temporary political truce, with the Home Rule Act suspended for the duration of hostilities. Any hope that the Irish question might similarly be placed into suspension was rudely shattered by the Easter Rising, Easter 1916, in which a small force of paramilitaries under the leadership of Padraig Pearse occupied a number of buildings in central Dublin and proclaimed the birth of an Irish Republic. The German Empire, adopting the well-known strategy that my enemy's enemy is my friend, had conveyed Sir Roger Casement to Ireland by submarine to lend his support to the rebellion there. Casement, an Irishman, had had a distinguished pre-war career as a British diplomat and humanitarian activist before becoming a strong proponent of Irish independence. He had made his way to Germany, where he tried recruiting an Irish brigade to fight the British from Irish prisoners of war. In the event, the rising was suppressed by overwhelming Crown force. Casement was arrested very shortly after coming ashore, and these events formed the backdrop to the first two cases in the English courts, which I wanted to consider. The first in time, in 1916, was Casement's trial before a jury at the Old Bailey and his subsequent appeal to the Court of Criminal Appeal. He was tried for high treason in contravention of the Treason Act 1351 before the Lord Chief Justice, Lord Reading, Mr Justice Avery, Mr Justice Horridge, and a jury. And as Attorney General, FE prosecuted, doing so in grand style, albeit in a manner which would not have passed muster with modern standards of prosecutorial conduct. Recounting Casement's distinguished pre-war career and the events which had led to him coming ashore at Tralee in April 1916, FE concluded his opening by stating, "Rhetoric would be misplaced, for the proved facts are far more eloquent than words. The prisoner, blinded by a hatred to this country, as malignant in quality as it was sudden in origin, has played a desperate hazard. He has played it and has lost it. Today, the forfeit is claimed." Like the late Professor Connegherty, a much missed member of this inn, I do not believe it to be seriously arguable that Casement did not receive a trial which was fair by the standards of his day. Indeed, in many ways, his trial was almost a studied exercise in fairness. Despite initial difficulties, he was represented by solicitors and counsel. The timing of the trial and subsequent appeal were adjusted to meet their requirements. Criticism of FE's conduct largely concerned an unsuccessful attempt to get Casement's counsel to read his client's personal diary, which revealed Casement's secret life as a sexually active gay man in a deeply homophobic age, and also FE's boorish response to Casement's compelling speech from the dock. The latter, I suspect, was an attempt to conceal quite how effectively Casement barbs at FE had hit their target, contrasting his own involvement supporting nationalist rebels with FE's pre-war support for those engaging in armed resistance to Home Rule. Casement said, "The difference between us is that the Unionist champions chose a path they felt would lead to the woolsack, while I went a road that I knew would lead to the dock." Sergeant Sullivan, who was Casement's principal counsel's main argument, was that the Treason Act did not extend to treasonous acts committed abroad. In Casement's case, recruiting those prisoners of war in camps in Germany. That involved a considerable focus on the location of commas in the original vellum version of that 1351 statute. That is perhaps an even more famous role for that particular form of punctuation than the question of what we should understand when we are told that a panda eats, shoots, and leaves. The argument predictably failed at first instance and on appeal, the latter occasion being the subject of a very famous courtroom painting by the Irish artist Sir John Lavery. The painting was commissioned by one of the appeal judges, Sir Charles Darling, and it depicts my own judicial hero, Sir Thomas Scrutton, amongst the bench of five. The second case arose from the very different conditions in which those arrested for their participation in the Rising were tried and convicted by military court-martial following the proclamation of martial law, court-martials which culminated in 15 executions by firing squad. The legalities of the largely Dublin court-martials are themselves a great source of interest and drama. But my subject today is the court proceedings begun in England in 1917 to challenge the trials of two rebels who'd avoided the death sentences, Gerald Doyle and Cornelius O'Donovan. They brought a variety of challenges to the legality of their convictions, including the fact that the proceedings had been unlawfully conducted in secret. Those challenges were heard by a divisional court comprising the Lord Chief Justice, Lord Reading, Mr Justice Baylash, and Mr Justice Atkin, of course, famous member of this inn. Effie appeared for the Crown and made what is inevitably the Crown's best point in a case of this nature, that if the application were to succeed, the proceedings of many, if not all, of the recent courts-martial in Dublin were invalid and irregular, and the result would be a great and irreparable public mischief. The Sir James Atkin of the Great War had some distance to travel before his seminal dissenting judgment against interment without trial in Liversedge and Anderson in the Second World War. In 1916, he'd been one of the judges who upheld a similar power of interment without trial in Crown and Halliday, and he was similarly unmoved in Doyle, that the argument was sufficiently formidable for the hearing to be reconvened for further argument before a special divisional court composed of 7 judges. When giving a lecture to students of this inn after the Great War, Lord Atkin advised, "Do not make too many points. You will be lucky if you have 2 good ones. Counsel during the last war opened a habeas corpus case before a court of which I was a member by saying he had 15 points. He was a very experienced counsel, and needless to say, they were all bad." That was, I am sure, good advice, but lurking amongst Schiller's 14 points, as they were, was one very good point indeed, the holding of the courts-martial behind closed doors. The relevant rules for the conduct of courts-martial did not give the court an express power to sit in camera. FE, as Attorney General, and the Solicitor General, Sir Gordon Hewitt, had advised the government there was no such power. Even if there was, then, as with any court, it was one to be exercised judicially by the court, having regard to the circumstances prevailing when the question of sitting in private arose. But that was not what had happened. General Sir John Maxwell, the military officer sent to suppress the Rising, had decided early on that all the courts-martial would be heard in private. He did that without consulting any civil or military authority. That order was thereafter acted upon without discussion or consideration by the military tribunals, even after Maxwell had proclaimed that the Rising had been suppressed and that conditions in Dublin were fast returning to normal. And yet the challenge brought by Doyle and O'Donovan failed, the 7-judge court holding unanimously that the court-martials had been regularly and lawfully conducted. Lord Reading held that although a court-martial was a creature of statute, there was an inherent jurisdiction to sit in private, and the court inferred without any evidence that the officers must have held the same view as that propounded by General Maxwell at an earlier time, when the rising was in full flow. The Solicitor's Journal described the judgment as a grave step, and so it was. Now, the next case, we move to a later stage in the Anglo-Irish conflict, which after a brief period of quietus after the Easter Rising had erupted into a large-scale guerrilla war. The beginning of that is generally linked to the shooting of two members of the Royal Irish Constabulary at Solohead Beg, County Tipperary, in January 1919. In addition to widespread revolutionary and counter-revolutionary violence in Ireland, the military forces of the independence movement carried their campaign to the British mainland. Arson attacks, bombings, and shootings across the UK led to numerous criminal convictions. But although the criminal justice system was fully functioning, the government decided to intern suspects without trial, a policy adopted during the Great War for Enemy Aliens and continued in Ireland thereafter. Emergency law in Ireland had been implemented by adopting regulations made under the Defence of the Realm Acts wholesale under a new statute, the Restoration of Order in Ireland Act 1920. That included Regulation 14B, the internment without trial regulation. But not content with the policy of interning suspects in Ireland, where the Crown criminal justice system had essentially broken down, the government decided to use that regulation to arrest Republicans suspected of offences in England and then send them to Ireland to be held in military camps there rather than trying them. The law officers had advised the Cabinet that the use of Regulation 14B for this purpose was ultra vires and unlawful. The Republican movement's legal advisers had also identified this issue and looked for a suitable detainee to bring the challenge. The individual duly presented himself in the form of Edward Brady. In 1961, Brady's counsel, Joshua Caswell, KC, wrote a memoir of his life as an advocate called A Lance for Liberty, in which he described Brady as, quote, a frank, open-faced Irish youth of 18 who had lived in this country for 5 years and taken no part in Sinn Féin activities. Some 33 years before, Brady had written his own memoir addressing his life in Britain, including the activities which had led to his internment. The accuracy of Caswell's description can be seen from the title of Brady's book, Ireland's Secret Service in England, How Little Barristers Sometimes Know Their Clients. Caswell received a rather dusty response from the Lord Chief Justice, Andrew Lawrence, when the writ of habeas corpus was first moved, but the Crown was required to show cause why it should not be issued. On the return date, a court comprising Lawrence, Shearman, and Sankey rejected the application, holding that the restoration of order in Ireland might indeed require detention without trial in England or elsewhere. An appeal came before Lord Justices Banks, Warrington, and Scrutton in the Court of Appeal. It failed, but brought out a coruscating dissent by Scrutton, who chided the majority by observing, "Where I begin to differ from my brothers is that they approach this statute to find any reasons why England should not be included. I approach this statute to find clear words to show England is included." He did not find them. He also castigated the incredibly slovenly way in which Defence of the Realm regulations, covering the broad field necessary for economic and state control in a time of total war, had been adopted wholesale under an act intended to address the Irish rebellion. He said why they thought it was necessary to put in for the restoration of order in Ireland a regulation providing for the securing for the supply of the country of any migratory kind of wild bird, I am quite unable to conceive. Here, in my view, is where the truly great English dissenting judgment in a civil liberties case is to be found, and I regret to say it hails not from this inn, but from the Middle Temple. In January 1919, Effie was appointed the youngest ever Lord Chancellor. and that in a day and age when whole years could go by without a new Lord Chancellor being sworn in. In that capacity, he played a key role in the coalition government's response to the Irish insurgency over the following 3 years. He began in his 1914 mode, implacable in any opposition to any form of Irish self-determination and demanding coercion full blast in cabinet. But by June 1921, he was coming round to Churchill's view that jaw was better than war. By the time the appeal in Brady was heard, a truce had been agreed between Crown and Republican forces to allow for negotiations for a political settlement. The Irish delegation was led by Michael Collins, the key British representatives being David Lloyd George, the Prime Minister, F.E. himself, and Churchill. There were then intense negotiations over a 2-month period in which F.E. and Collins played the crucial roles. It still astonishes me that against all odds, the negotiations managed to deliver a treaty by which Ireland was given a Dominion status equivalent to Canada, the 6 counties of Ulster the right to opt out of what was now to be the Irish Free State, and British military forces to be withdrawn from Ireland, with the exception of 3 ports of supposed strategic significance. The terms of the treaty proved highly divisive in both British and Irish society. In Britain, it was one of the factors which led to the fall of the coalition government in which F.E. had been such a key figure. In Ireland, the fallout went beyond the metaphorical civil war of the Conservative Party, with the outbreak of a bloody conflict between pro- and anti-treaty forces. The provisional government of the Irish Free State, the pro-treaty party, sought British government assistance in that struggle, including by rounding up anti-treaty Republicans on the mainland, interning them under Regulation 14B, and then deporting them to be held in camps in Ireland under the control of the Irish Free State. I think that is a process, arresting someone without trial and sending them abroad, we would now recognise as one of extraordinary rendition. About 116 Irishmen were grabbed off the British streets and sent by destroyer to be interned in Ireland. The civil servant given the order was Sir John Anderson of Liversedge and Anderson fame, and whose name marked the Anderson shelter. He presciently warned there's bound to be a fuss about this, but the Attorney General of the day, Sir Douglas Hock, pooh-poohed those concerns and assured the Home Secretary, Sir Walter Bridgeman, that all would be well. In the event, the ex-party application for habeas corpus was brought by Art O'Brien, who is the leading representative of the Sinn Féin movement in the United Kingdom. He argued that the bringing into existence of the new Dominion in the form of the Irish Free State had abrogated the Restoration of Order in Ireland Act 1920 and the regulations made thereunder. The application was initially heard by Lord Hewitt, who had vacated the role of Attorney General to move into what was then the Attorney General's legitimate claim, Lord Chief Justice, sitting with Mr Justice Roach and Mr Justice Avery. Very shortly before taking his appointment, he had advised the government as Attorney General that Regulation 14B could still be relied upon, notwithstanding the coming to power of the Free State. Against that background, it's perhaps unsurprising that he found O'Brien's application for habeas corpus was so hopeless, he didn't even require the Crown to show cause to justify the detention. Fortunately, the Court of Appeal took a different view. Sir Douglas Hogg for the Crown at that point made the most remarkable argument. Habeas corpus would not issue against the Home Secretary because the detainee was no longer in his power, having been handed over to the government of an independent state. In addition, on the first day of the hearing, the Crown passed an order in council intended to improve its position in the argument to follow. It was all in vain. The Court of Appeal unanimously ordered the Home Secretary to produce O'Brien. There was another tour de force from Scrutton, who began by stating, "The law of this country has been very jealous of any infringement of personal liberty. This care is not to be exercised less vigilantly because the subject whose liberty is in question may not be particularly meritorious. It is indeed one test of belief in principles if you apply them to cases with which you have no sympathy at all. You really believe in freedom of speech if you are willing to allow it to men whose opinions seem to you wrong and even dangerous. Scrutton held that Regulation 14b had only ever justified detention under the control of the Home Secretary, but that in any event the continued existence of that power was inconsistent with legislation recognising a new executive government in the Irish Free State. So far as the orders in council were concerned, he observed sarcastically, "It's perhaps beyond the function of His Majesty's judges to criticise the advice which His Majesty's ministers give to His Majesty as to the issuing of orders in council, but it may be permissible to say respectfully that it adds a new terror to litigation with government officials if they can make orders in council while a case is being argued to assist their argument." On this occasion, Lord Justice Atkin was on the side of the angels, as was Lord Justice Banks. Now, ordinarily, no appeal lay against an order for an issue of the writ of habeas corpus, because the liberty of the subject was not to be subject to the delay and uncertainty of ordinary litigation. But the Crown had rushed an appeal to the House of Lords in the period between the Court of Appeal making the order of habeas and the date they had fixed for O'Brien's production. The appeal to the House of Lords was heard 2 days before the return date, and F.E., as a former Lord Chancellor, was one of the Constitution hearing the appeal. The House rejected the Crown's appeal, holding that no right of appeal lay, even in the period before O'Brien had to be produced. F.E. was utterly scathing of the Crown's case, observing, "The argument, my lords, is one of the most remarkable which I have either heard or read from the lips of the executive in attempting to pronounce upon the liberty of the subject. A dog is still limited to a single bite. The Home Secretary, more happily provided for, can obtain an appeal otherwise denied him by 2. Now, Article 2 of the Anglo-Irish Treaty, as I have mentioned, had provided that the status of the Irish Free State in relation to the Imperial Parliament and government and otherwise shall be that of the Dominion of Canada. There are conflicting explanations for the absence of any express statement that the state of affairs thus described involved an appeal from the Irish courts to the Privy Council. Either the British delegation did not make this clear to the Irish delegation, or they did, but the Irish delegation preferred that not to appear from the face of the document they were about to take back to Dublin. But the issue did surface when the proposed constitution of the Irish Free State had to be prepared, which in its final form provided for such an appeal in Article 66. Now, early attempts to bring appeals from the Irish Supreme Court to the Privy Council were rejected by the then Lord Chancellor, Lord Haldane, who stressed that appeals should rarely be granted, and the Irish Free State must in large measure be left to dispose of her own justice. But that all changed when his successor, Lord Cave, granted leave in Linham and Butler, a case concerned with the Irish Land Act. In response to the granting of leave, the Irish Parliament, the Dáil, rapidly passed a statute giving legislative effect to the Irish Supreme Court's interpretation, rendering the appeal pointless. The same expedient was adopted when the Privy Council gave leave in a case concerning the Copyright Act. The one occasion on which the Irish government did engage in a Privy Council appeal concerned a dispute as to the amount of compensation to be paid to Crown civil servants who had been transferred to the Irish Free State under the treaty if their employment subsequently ceased, that being a subject expressly addressed in Article 10 of the treaty. Retired civil servants in Ireland brought court proceedings to challenge the amount of compensation they had been offered in a case called Wigan Cochrane and the Attorney General, but the Irish Supreme Court rejected their claims on the basis they had no legally maintainable cause of action. The Privy Council reversed that decision holding that Article 10 of the treaty, as incorporated in the Irish Constitution, gave such a claim, but they also upheld the civil servants' claim to a higher level of compensation. In doing so, the board had made a factual error. They wrongly thought the civil servants had been transferred to the Irish government before a new Treasury Minute of March 1922, imposing more restrictive compensation, had been introduced. The reality was it had happened after. The Irish government, for that reason, refused to implement the decision. Lord Cave, who had written the opinion, had been in poor health at the time. He died just under a year later. And over those 11 months, he became increasingly anxious about the decision. 3 days before he died, he dictated a letter to his wife to be sent to the Prime Minister, Sir Stanley Baldwin, stating the decision was probably wrong in law, and that for this error, the persons principally responsible are those who drafted the opinion. The plural notwithstanding, that was a reference to Cave himself. When the British government proposed to introduce legislation to reverse the Privy Council's interpretation, Lord Carlson introduced a debate in the House of Lords intending to forestall such a step. 2 members of the board in Whig participated in that debate. Viscount Haldane referred to Lord Cave's judgment being prepared, quotes, without any clear knowledge of the effect of the minute of March 1922, an issue which he said was one calling for careful inquiry. Lord Dunedin was more direct, saying it is no pleasant matter to stand in a white sheet and say that you were wrong. On the other hand, I think it is cowardly for a man to run away and not accept his share of responsibility. Now, if you are impressed by that willingness to acknowledge error on Lord Dunedin's part, it is perhaps somewhat undermined by what followed, the traditional judicial expedient of blaming counsel for errors of this kind. For he continued, I can only say that it is very curious that the counsel against whom the case was decided on that ground did not find it out. The judgment was circulated and there would have been plenty of time to have it put right. Lord Finlay, the last surviving member, was spared this public mea culpa because he was absent on grounds of ill health. But the final member, who Lord Dunedin confirmed had written the judgment, Lord Cave, did speak from the grave through the medium of none other than F.E. F.E. told the House the opinion of the board was indisputably and unarguably wrong. Advocate at heart that F.E. remained, he was a little kinder to counsel, saying everyone who has long experience of litigation knows how easy it is for the most industrious counsel to overlook some material. He told the House of Lord Cave's change of heart almost within a period of 24 hours before his death. Lord Reading, the former Lord Chief Justice, suggested at this point that the issue be referred back to the Privy Council. And that is what happened, the reference being made under Section 4 of the Judicial Committee Act 1833. There the board was presided over by none other than Lord Reading himself, who undertook a lengthy and learned analysis of whether the board could revisit an earlier decision, concluding that it could. Having done so, the board then pronounced that the error about the March minute notwithstanding, the board's original decision in Whig was correct after all. So much labour for so little product. In the event, legislation in both jurisdictions achieved the mutually desired outcome. The Irish Free State sought to address the Privy Council appeal at imperial conferences in 1926 and 1930, attended by the self-governing dominions and representatives of India. At the 1926 conference, they didn't receive the level of support from other dominions for which they had hoped in a campaign to restrict or abolish the appeal. But they did receive support from F.E., present in his capacity as Secretary of State for India in the Indian summer of his political career. But Lord Cave thwarted F.E.'s proposal for a subcommittee to consider a means of restricting Irish appeals. F.E. met the Irish in private, including at a dinner with the Irish Foreign Minister Kevin O'Higgins and the Australian Prime Minister Stanley Bruce, advising them as to how best to pursue the issue at the next imperial conference 4 years hence. But their efforts were in vain. F.E. died the day before the 1930 conference began, and in any event, by then, his party was out of power. The Irish were no more successful than they had been in 1926. The British government advancing the position that any Dominion reform would not in any event affect the Irish position, because the treaty had an overriding contractual effect, and because it had given the Irish Free State the constitutional status of Canada in 1921, not as it subsequently developed. But there was one significant constitutional development to which the Irish delegation to the 1926 conference, and Kevin O'Higgins in particular, had made a major contribution, and that was the proposal which later became the Statute of Westminster of 1931. That would remove the power of the United Kingdom Parliament to legislate for the Dominions without their consent, provide that no legislation of any Dominion enacted after the statute would be void or inoperative on the basis of inconsistency with UK law, and recognise the Dominions could repeal prior UK acts to the extent to which they purported to apply to them. The effect that the proposed statute would have on the treaty and the Irish appeal to the Privy Council, not surprisingly, had received very close scrutiny, and there was an amendment proposed to make it clear the statute would not impact on the treaty. It was dropped after Stanley Baldwin, then a minister in the national government, informed the House of Commons that the government had been advised that the passing of the Statute of Westminster would not affect Ireland's treaty obligations. That was indeed the advice given by Sir Thomas Inskip, the Attorney General, and the statute was duly enacted in December 1931. Early the following year, the anti-treaty party of Eamon de Valera won the Irish general election. He soon introduced an amendment bill to remove the reference to a Privy Council case from Article 66 of the Irish Constitution. Now, the efficacy of that reform was to be tested in proceedings brought in Ireland by local fishermen, seeking to challenge the right of the Protestant-owned Erne Fishery Company to a private fishery on the River Erne's tidal estuary in Donegal. The company was able to trace its rights back over 3 centuries, but found its claim opposed on even more ancient grounds by reference to a provision in Chapter 16 of Magna Carta, said to prevent new private fisheries being created after 1189. That preceded the arrival of the common law in Ireland, and it was argued that Brehon law, Irish native law predating the British conquest, did not recognise a private right in fisheries, such that there were no rights pre-existing what was supposed to be the Magna Carta watershed. The company brought proceedings in the Irish High Court seeking a declaration as to their title, which was heard by Mr Justice William Johnston. Johnston had been appointed a county court judge for Monaghan and Fermanagh in 1911, where his genial disposition earned him the nickname Civil Bill. That is a joke which worked rather better under the then prevailing civil procedure regime than it does under the CPR. He was also something of a legal historian, having written a number of articles on that subject in the Law Quarterly Review. He was one of the few judges appointed by the British to be reappointed to the Irish High Court in 1924, and he was, I am delighted to say, a member of this inn. The argument before him lasted 21 days, with the fishermen, supported by the Irish government who had intervened, adducing evidence of Brehon law from Professors Owen MacNeill and Daniel Binchy. The company had no supporting expert evidence. But unfortunately for the fishermen, Civil Bill was no stranger to the concept of Brehon law. One of his Law Quarterly Review articles having analysed the gradual displacing of that vast but indeterminate body of fluctuating maxims and juridical opinions called the Brehon law after the arrival of the common law in Ireland. His very impressive and thorough judgment reviewed the legal sources relied upon by the experts and concluded their evidence was nothing more than antiquarian speculation. His judgment has largely been vindicated by subsequent generations of legal scholarship, with Binchy himself later changing his mind and his evidence. But his judgment was overturned by a majority on appeal to the Irish Supreme Court, and in a spirit of even-handedness, it must be noted that that judgment is no triumph of Irish jurisprudence, The majority judgments are cursory, wholly unpersuasive, and make no attempt to engage with the detail of Johnson's analysis. But nonetheless, the fishermen had won. Frank Gallagher, their solicitor, told an exultant crowd they had snapped another of the links of the chain of steel with which this country has been bound for hundreds of years, referring to the company as foreigners with their spurious fishing rights, to which they stuck with the tenacity of brallions on barnacles. Now, with just such tenacity, the company sought to appeal to the Privy Council, ignoring de Valera's warning that if an appeal was attempted, it would be rendered ineffective. The appeal was heard in December 1934 and January 1935, with the preliminary question being whether the Privy Council's jurisdiction had been removed by the Irish Free State Constitutional Amendment. Neither the de Valera government nor the Kildonia fishermen took any part, but one Attorney General did appear, Sir Thomas Inskip, having advised the House of Commons in that capacity that the terms of the treaty prevailed over the Statute of Westminster. He duly appeared to advance that argument to the board. The board therefore found itself hearing from two parties arguing that the Irish constitutional amendment was ineffective, and no one presenting the opposing point of view. And yet that opposing point of view prevailed. The board deciding the effect of the Statute of Westminster was that the Irish Parliament could legislate in terms inconsistent with the treaty, and they had done so. That result is, I think, rather magnificent. It can be said, I think, that nothing became Ireland's relationship with the Privy Council like the manner of leaving it. In a speech memorable for both its prose and content, Effie's close friend Winston Churchill introduced the bill intended to give effect to the treaty in February 1922. Referring to the cataclysm of the Great War, he spoke of how the whole map of Europe has been changed, the modes of thought of men, the whole outlook on affairs, the grouping of parties, all have encountered violent and tremendous changes in that deluge of the world. But, he continued, as the deluge subsides and the waters fall short, we see the dreary steeples of Fermanagh and Tyrone emerging once again. The integrity of their quarrel is one of the few institutions that has been unaltered in the cataclysm which has swept the world. After the Erne fishery case, there was indeed a long period when the Irish question largely receded from the English courts. But that changed when the Northern Irish state, created by the Government of Ireland Act 1920, once again moved to the centre of British consciousness in the 1960s, with civil rights protests, tragic civilian deaths, an outbreak of terrorist violence, and a state response, which was to endure for another 30 years. Its principal legal legacy in this jurisdiction, I fear, is a series of miscarriages of justice, which blighted the lives of those wrongly convicted, just as the IRA's campaign had blighted the lives of so many innocent victims. But then, as with Effie and Michael Collins in 1921, political courage and goodwill paved the way for a fresh settlement. A key staging post was the Anglo-Irish Agreement signed by John Major, our Prime Minister, and Garrett Fitzgerald, the Irish Taoiseach, in 1985, providing for an intergovernmental conference between the two countries to discuss the relationship of the North and South of Ireland. 4 members of the Ulster Unionist Council brought proceedings in the English court, seeking a declaration that it would be unlawful to implement that agreement on the basis that it was contrary to Article 6 of the Act of Union, which provided that in all dealings with foreign powers, His Majesty's subjects in Ireland were to be treated the same way as those in England. Leave was refused on paper, but orally renewed before Mr Justice Taylor in ex parte Molyneux. The application failed, because although the Irish Republic, as it had become, declared that status in 1949, the United Kingdom Parliament passed a statute in response to say that Ireland nonetheless would not be treated as a foreign country. The Good Friday Agreement of April 1998 has been extensively litigated in the Northern Irish courts, but so far as I can tell, the English judiciary have not had to grapple with it directly. But the complex set of constitutional arrangements which it brought into being were clearly lurking in the undergrowth when the English courts engaged with our most recent constitutional upheavals, the leaving of the European Union, in Miller 1 and Miller 2. This new iteration of the Irish question, the effect of the special constitutional status of Northern Ireland on the UK's withdrawal from the EU, was addressed in a document called Protocol on Ireland, Northern Ireland, signed by the EU and the UK. That agreement honoured its antecedents in Anglo-Irish history by being a document whose signatories professed fundamentally different understandings of what they were signing. Once again, it's featured prominently in court proceedings in Northern Ireland, including one case which proceeded to the Supreme Court, which rejected an argument that it was inconsistent with the Acts of Union. But its only appearance to date in the English court was not quite so constitutionally momentous. It came before me as a subsidiary argument in a challenge to UK sugar tariffs, it being suggested the UK's government's policy was unlawful because of its potential effect on the market for refined sugar in Northern Ireland. In responding to that argument, I was unable to resist a brief nod to Churchill's comment of almost exactly a century before, when I noted that sugar refined outside Northern Ireland is sold and consumed there. It is no doubt one of the cheering staples of Fermanagh and Tyrone. That moment of bathos is, I think, a propitious time to bring this lecture to an end, and in doing so, I offer three final thoughts. First, I think it's fair to say the engagement of English law with the Irish question offers a mixed report card for the English courts. There are decisions and certainly individual judgments of which we can be justly proud, others which give cause for profound soul-searching. In whatever fresh political controversies we may find ourselves involved, we should draw inspiration from those judges who were able to insulate themselves from the prevailing tumult and for whom the requirements of law and due process remained the sole determinants of their decision. In the words of John Bode's hymn, which we sung at this year's legal service to mark the opening of the legal year in Westminster Abbey, their judgments speak to us in accents clear and still, above the storms of passion, the murmurs of self-will. Second, it's pleasing to note that despite, or perhaps in part because of our shared history, the relationship of the Irish and English bars and the Irish and English judiciaries remains a very strong one, with a palpable sense of kinship and mutual respect. One vivid demonstration of that connection is Sir John Lavery's painting of Casement's Appeal, which hangs proudly in the King's Inns in Dublin, and of which the visiting Lady Chief Justice of England and Wales was treated to a guided tour by the Chief Justice of Ireland last year. There are family relationships which bridge the digital divide. I was delighted to discover early this year I have a second cousin on the Irish High Court bench, Justice David Keane. And finally, what of F.E.? I've traced his journey on the Irish question from provocateur to prosecutor, from propagandist to peacemaker and partner in reform. He and Collins produced an agreement which brought a significant measure of peace to Anglo-Irish relations, and for a significant period. Collins and F.E. came to develop a strong mutual respect, each conscious of the huge risks they were taking, and their leap of political courage had serious consequences for both. For F.E., dissatisfaction with the treaty was one of the reasons for the fall of the coalition government, effectively ending his career in the highest office. The treaty proved a much greater personal tragedy for Collins, killed at Béal-na-Blór on the 22nd of August 1922 in the course of the Irish Civil War. It's said that F.E. was intent on flying to Dublin for Collins' funeral, the significant danger notwithstanding, before fog intervened and the flight had to be cancelled. Adverse meteorological reports apart, I found no direct support for that story, but I hope it's true. I like to think of F.E. as he waited for news of his flight, pondering his own involvement in the Irish question over 3 and more decades. Recalling his most famous courtroom quip, I like to think that as he did so, he found himself both wiser and considerably better informed. Thank you.
You. From the accent, you can tell a bit of a personal, yeah, that was fun to listen to. There are increasing calls for the UK to withdraw from the ECHR, a core pillar of the Good Friday Agreement. Do you imagine that reaching English courts and being a future part of a talk like this?
I think that brings us from history beyond the contemporary to the topical now. And I'm afraid at that point, the judicial shutters in public debates have to come down. I'm sorry. That's I see it's from a fellow country person.
A proud member of Middletown as well. I brought up by Irish parents, and my entire family background was Irish. Had been led to believe that Effie Smith was one of the bogeymen. And I wonder now if that is the baby, or whether my ancestors were right to think of me as somebody who sat down.
I think it sort of depends upon the period you are concerned, but there is no doubt from 1921, when he had decided on a negotiation, he absolutely threw himself behind getting a treaty. He was prepared to contemplate solutions which would have been unthinkable before. And I think more importantly than that, in the period after the treaty, he remained faithful to its spirit and to making it work in a way perhaps that Churchill, a fellow signatory, did not. And so I think, as I say, he is a man of many parts. The 1914 FE, I do find and understand what is said about him. I mean, that was out and out insurrection being urged from the safety of someone within the protection of the establishment. But 1921 onwards, you'd have to say he was absolutely devotedly committed to making the treaty work.
Seeing as Effie did obviously move his opinion through his life, and as you say, the difference between 1914 to 1921, do you think it was just better understanding the question, or do you think the Great War and the 1916 Easter Uprising affected his view?
I think when he first arrived in government in 1919, he remained a diehard. I suspect that a realization that the military commitment required to subdue Ireland and its economic cost was one that the post-First World War economy was going to find it difficult to bear was a factor. But there is no doubt that personal relationships did play a very significant part. And, you know, it wasn't all one way. You will find comments from Collins recognizing that, you know, FE was the one person he really admired and valued on the British side. And I think that the sort of the personal connection between them was the key dynamic in those negotiations from June to December 1921. In all that followed, FE regarded the Anglo-Irish Treaty as the crowning achievement of his life. And he was right.
Through now, so I'm just yeah, there's just one about whether female voices involved in the and the decision. I think
So far as the Irish independence movement is concerned, there were a number of significant women voices. Constance Markievicz was, rather than Lady Astor, was the first woman elected to the House of Commons. But of course, as a Sinn Féin abstentionist, she did not take up her seat. And there were a number of other people who, in the heady period in Irish independence movement between, I would say, sort of 1917 and 1922, looked as though they were going to be allowed a very significant active and political voice. I'm afraid that revolution against the British having been achieved, a social counter-revolution rather than set in Ireland, and it, I think, took then a significant while before at national level those women voices were able to reassert themselves again. I mean, in this jurisdiction, there were a number of prominent women who spoke out against what they saw as the excesses of Crown Forces conduct in Ireland. But there is no doubt that obviously the judges, we had, until the Sex Disqualification and Removal Act in 1919, there were no women solicitors or barristers. There certainly were no judges. And so the rogues gallery or heroes gallery of photographs that goes up is, I fear, almost exclusively male for that reason.
Hi, you spoke a fair bit about Smith's motivations regarding peace in the Republic around the 1920s negotiations. I was hoping you might also speak a bit about his motivations with regard to the North and perhaps any continuities between his earlier days and then the motivations he brought into constructing a northern state as well as a southern one in that time.
Yeah, I think the six-county opt-out, which the treaty contained, which made it possible for the separate parliament brought into existence by the Government of Ireland Act 1920 to continue, probably made Effie's journey in the treaty easier than it had been. I think some noises may have been made in the negotiations that a provision for redistribution of the boundary might make that northern state unviable. When it came to operate those provisions after the treaty had been brought into effect, there appeared to be different understandings on the part of the British and Irish delegations as to what they meant, and it ended up with no transfer of territory either way. Carson certainly put his efforts into establishing the northern state, although having done so, spent relatively little time there. But there is a massive statue of him outside Stormont Castle with his arm raised. So he is remembered there, even if he didn't choose to spend, as a Dubliner, too much time there.
Oh, the last one, yeah.
This colonial period?
So I think I got that, but the amplification only came, but it was looking at whether there were other British colonies who were influenced by or looked to Ireland as an example for their own independence movement. That is certainly the case. I think the India in particular followed, the Indian independence movement was following very closely what was happening in Ireland, although occupied territory rather than formally a colony. Egypt as well at that stage was following closely. And indeed, even within Canada and South Africa, the appeal to the Privy Council was not a hugely popular constitutional feature, nor the idea that imperial legislation might override their own domestic parliaments. And I think that's why Kevin O'Higgins, the Irish foreign minister, was able to gather together the support at the Imperial Convention, which led to the Statute of Westminster and which allowed Ireland, within the confines of the existing arrangement, to do away with the Privy Council appeal.
Agree with me that that was an extremely learned and very stimulating talk. I anticipated nothing less from our speaker. Will you please join with me in a very warm round of applause before we go?